Shiri Rao Inderjit Singh will be arriving shortly. I request all the guests to kindly be seated and keep their phones on silent mode, please.
The research part was a bit botched up because we had too many people. So we should have just done a single track. Later I realized.
But this time,
This time the very decent papers actually.
I was happy to see the papers. We got the papers.
No, and the thing is that there's a lot more research now also, right? In the last 2-3 years on this topic. So
More time, more data.
So who was in charge of the flowers? No.
Ladies and gentlemen, our chief guest for the occasion, Honorable Minister of State, Shri Rao Inderjit Singh is arriving. To be able to do that, you can give it to ITT. That's मुझे कुछ नहीं करना है. Ladies and gentlemen, may we have a huge round of applause to welcome our esteemed guest on the dais. I welcome you all to this event of International Research Conference on Insolvency and Bankruptcy organized by IBBI in association with IIMA Ahmedabad. May I please call upon Professor Sanket Mohapatra, Chairperson, Mishra Center for Financial Markets and Economy, to welcome our esteemed guest on the dais. Sir, may I please request you to address the audience, please?
1 minute, Mr. Rao is coming.
Yes, we'll wait.
The owner.
Definitely, we'll wait.
1 minute.
Thank you. Should we start? So good morning, everyone. On behalf of IIM Ahmedabad and the Mishra Center for Financial Markets and Economy, I extend a hearty welcome to all the distinguished guests, participants, esteemed faculty colleagues, researchers, and students to the International Research Conference on Insolvency and Bankruptcy. The two-day International Research Conference brings together academics and researchers, lawyers, economists, regulators, and the private sector to promote research and discourse in the field of insolvency and bankruptcy. This conference is organized jointly by IIM Ahmedabad and the Insolvency and Bankruptcy Board of India, marking a confluence of policy and research. I would like to acknowledge the important role played by Professors Abhiman Das and MP Ram Mohan of IIM Ahmedabad, along with colleagues from the IBBI and the Ministry of Corporate Affairs, Dr. Kokila Jayaram, Dr. Anuradha Guru, and Shri Ritesh Kabdia in organizing the conference. The Mishra Center at IIM Ahmedabad is pleased to support the conference. The Mishra Center is involved in building quality data, analytics, and insightful knowledge of the Indian financial markets and the economy, and engages with relevant stakeholders who influence policies as well as those who are significantly affected by policies. With that, let me take the opportunity to introduce the distinguished guests. Today, we are fortunate to have with us Shri Rao Inderjit Singh, Honorable Minister of State with independent charge for the Ministry of Statistics and Program Implementation, the Ministry of Planning, and the Ministry of Corporate Affairs. Shri Rajesh Verma, Secretary for the Ministry of Corporate Affairs. Shri M Rajeshwar Rao, Deputy Governor of the Reserve Bank of India. Shri Ravi Mittal, Chairperson of the Insolvency and the Bankruptcy Board of India, and Professor Errol D'Souza, Director of IIM Ahmedabad. I would now request the esteemed guests to come to the dais for lighting the lamp.
Thank you, dear dignitaries. I would now like to request our esteemed guest, Professor Errol D'Souza, to deliver the welcome address, please. Mr. D'Souza is a professor of economics and the director at Indian Institute of Management, Ahmedabad. He has been associated with various government departments in his illustrious career. Sir, may I please request you to deliver the welcoming remarks? Thank you.
Shri Rao Inderjit Singh, who is the Honorable Minister of State, who is with us. Shri Ravi Mittal, Chairperson of the IBBI. Shri Rajeshwar Rao, the Deputy Governor of the RBI, and Shri Rajesh Verma, Secretary, and other colleagues who are here, including the justices who have come from the NCLT and many others who I see, esteemed colleagues. It's a pleasure to welcome you all at IIMA for this very important conference. This is actually the second that we have had, and unfortunately we couldn't have one after the 2019 one, which was on a similar theme because of COVID, obviously, and it's great to see people back in a physical setting at this conference. Okay? Just a few months ago, the Parliamentary Standing Committee on Finance, had put up some issues with regard to the insolvency and bankruptcy issues, and some of the findings that they reported were interesting, and we thought it's a great opportunity to go back to the drawing board and think about what's happening in this very important part of the economy. Some of the findings were that you actually had haircuts given in something like 95% of the cases. You had delays beyond 180 days, again in some 70% or more of the cases. And most interestingly, when they were there were disciplinary orders on solvency professionals. If I remember the data correctly, it was something like 123 insolvency professionals were caught for disciplinary orders out of some 203 who had actually been looked at. So it's not it's just a good opportunity to go back and think about what's been happening, and some of the papers that I've just saw are going to be presented, are going to be talking about some of these issues and making recommendations on how to go about taking this very important institution forward, because there's no doubt about the fact that this has been a landmark change in the Indian setup. Okay? If we go back to just thinking about actually what a good bankruptcy procedure is, and if we were to go back to just thinking about design principles on this, then there are some very clear guidelines, and it seems like we've gone through that path quite carefully. If there were no bankruptcy law, then effectively someone who had credit due to them would basically have two recourses. If they were a secured creditor, then you would really ask that the collateral be sort of handed over to you. And if you're unsecured, you would go to a judge and ask that some of the assets of the organization be sold, and you get paid back. Okay? We know the problems with that. It is that if there are a large number of creditors, then everyone would want to go and make sure the assets are sold off as fast as possible. That is a huge loss of value for the organization, and so it's great to have a bankruptcy procedure in place. Okay? The first thing about such a procedure obviously is that this must be efficient ex ante. Okay? And when we say it should be efficient ex ante, we know that it basically means that when you issue debt, and you are foregoing equity, you're in a sense making a commitment to make payments out of future cash flows. And so you should ensure that that commitment is met if by chance the firm goes under. Okay? And there's no better way to do that than to say that shareholders should actually lose some of their rights, and maybe management should not have a right to continue either. Okay? And so a bankruptcy procedure is a very important part of making sure that that happens. Okay? But of course, there is the problem of how do you then distribute the value which is there in the organization. Okay? And mostly bankruptcy procedures follow some sort of a priority rule, which is that senior creditors should be paid off first, and then junior creditors, and eventually shareholders. Okay? And that seems to make sense, except when you think about it, ex ante, if you are in an organization which is you have the sense that it's going to go bankrupt, then there is an incentive for the management of the firm, to go for broke, because you would then ensure that you get some of the upside of the firm, and the risk is not yours, because anyway, if it goes broke, it is going to go under a bankruptcy, routine. And that means that we know about this in finance. We talk about this as asset substitution. The fact that even though you have a high quality project, you would substitute it with a low quality project just because there is a high chance, that you would get better returns and you would be able to keep the organization afloat. But that's not good for the organization. So a good distribution of value must have some role to play for shareholders. And that's something I find often missing in bankruptcy procedures, which is that it is all given to the creditors, which is to actually look at how to unwind the assets or how to liquidate the ongoing concern. If you look at it from the point of view of incentives, which is what people in finance and economics study, it's not the right structure of incentives maybe. Some value must be kept for shareholders so that they don't take this option of actually going for broke. After thinking about that, the second thing obviously is about what is the correct way of assigning decision rights. And obviously in our context, we've decided that we give it to creditors. There's a committee of creditors which will sort of look at the problem and would actually have a say in how to unwind the firm. But just think of an organization where the debt is approximately equal to the liquidation value, and supposing you give creditors the right to look at the problem. Obviously, their incentive is to liquidate the firm so that they get paid off. But the incentive of shareholders would be different. Their incentive would be try your best to reorganize the thing, because we will share in the upside, even though the risks might be there. So who do you give priority in terms of unwinding assets is again a very important sort of a component. In our case, the insolvency professional basically has a time window within which they have to come up with some plan. And they can, in that plan could involve a rejig of the corporate organization or a change in management or whatever. But finally, it has to be okayed by the committee of creditors. But even before the 180 days, the committee of creditors has the right to liquidate the firm. So that, to my mind, leads to what we in decision making call a type 1 error, because you're really pushing towards liquidation. If the firm is efficient and the assets are not really a problem, you should be reorganizing. But the whole incentive structure is really to move towards liquidation. It's the opposite of what would happen, let's say, in the US bankruptcy system, where they would make type 2 errors, which is that actually if the firm is inefficient, the incentive is to reorganize rather than to liquidate. So both systems do have problems, but we should recognize, that these problems are very much inherent, and that we are actually going down a path that we have predetermined, rather than kept it open as to what's the best valuation that can happen from a firm which is turned bankrupt. Finally, my small thoughts also on once you give creditors this sort of power, then obviously the argument is from the supply side, there would be an incentive for them to increase the flow of credit, and that's good news, right? Because now you're more in control of that flow of credit. And so actually that's a supply side phenomenon that we would actually see more credit flow in the economy, more new firms, and if firms go down, actually the capital gets restructured. But think of the demand side story. On the firm side, they would be more careful knowing that now there is more power on the creditor's side. And would they actually therefore take more capital? And if they would, how would they actually think about project financing? I'm not sure we have the empirical answer to this. I hope one of the papers in this thing is actually looking at something like this, because we focus too much on the supply side story. Okay? The demand side story is that if I'm on the management of a firm and I know creditor rights are very strong, okay, I would think twice about the type of loans that I take, and I would try to substitute with various other types of finance. Okay? So it is a problem that we need to also think about. Okay? So it is an opportune time to actually think about many issues. Okay? And this conference is an appropriate juncture for us to do so. Thank you so much to all of you for being here. I don't think we thought we would have, the type of response we got in terms of the number of paper presenters, etc. Otherwise, we would have chosen a bigger room for the inauguration. But it's a pleasure that honorable ministers also decided to come, and we are most heartened by our collaboration with the IBBI, who have actually been with us, on this journey, thinking about insolvency and bankruptcy for a few years. We look forward to the deliberations of the conference. We hope you have a pleasant stay. It's hot, yes, but I hope the ideas that are generated as heated and will generate a lot of light on a number of very important issues of the day. Thank you so much.
Thank you, sir, for your welcoming remarks. Certainly, your inputs will help the policymakers in introducing further reforms. Ladies and gentlemen, may I now like to introduce our guest of honor, Shiri Ravi Mittal. Shiri Mittal took charge as chairperson, Insolvency and Bankruptcy Board of India in February this year. He superannuated from the position of Secretary, Department of Sports, Ministry of Youth Affairs and Sports. He has also served in various ministries in his illustrious career. Sir is a 1986 batch Indian Administrative Officer. Sir, may I please request you to deliver the special address.
So good morning, everyone. So good morning, everyone. Honorable Minister Corporate Affairs, Deputy Governor RBI, Secretary MCA, other members on the dais. I see IBA Mehtaji, other members of my board, our whole-time member, researchers, officers from IBBI, from IIM Ahmedabad. So I welcome all of you to this international conference. I can see our three judges sitting here. It's an honor that they have also come here. So I welcome you all to this first international conference that we have organized with IIM Ahmedabad on insolvency issues. What we see is that we have had 6 years of IBC, and today we really need evidence-based research so as to take it forward. We need to understand as to where we have gone wrong and where we have gone right, and how to go ahead. And it is in this context that this conference should help us. The more than 50 research papers that are being presented today should help us in setting our policy directions, in helping us frame our regulations. I will give you 2 or 3 of my thoughts on the IBC process. I used to work in the banking ministry in mid 2015, and during those times NPAs were just rising, and we were really riddled with a big NPA problem. Banks were doing their own resolutions, but it was not working, and it is in this context that perhaps IBC came. And when I read IBC during that time, the first thing that struck me was that IBC prescribed timelines for everything. And I think that is the essence of IBC, that it prescribes as to what is to be done in how much time. Now, during the discussion in those days, we used to discuss as to why IBC is prescribing such tough timelines. I know that these timelines are very tough, and it is very difficult to resolve any asset in this timeline. But it was thought of, and I think it is still true, that value of assets go down very fast. There is a study which I saw 10-15 days back, which says that in the first year, the value goes down by about 30%. And then there is a 10 to 15% decline every year. Now, let us trace the journey of the project. When the promoter defaults on the payment, 90 days after that, the bank declares it a NPA. If you look at the RBI circular, it says that we have to wait for another 180 days. The RBI circular gives 180 days for the promoter and the bank to settle the issue. So 90 days plus 180 days plus 30 days, it is about 260, 270 days. So the project comes to NCLT or the project comes under IBC after 270 days. But this is the minimum. What we have seen is that projects are coming to IBC after 500 days, after 600 days. So what is happening is that 20-30% of the project value has already been lost when the project comes into the IBC process. And then the IBC process itself takes about a year or so, or more than a year. So when the project is finally bid out, it is about 2.5 to 3 years later than the first default. So naturally, what will happen is 40-50% of the project value has already been eroded. Now, we should not expect a bid which is the bank's debt, because 40-50% has already eroded. So I think the first thing that needs to be done is that projects have to come into the IBC process as early as possible. And my advice is, my thinking is that banks or financial creditors should send the projects just after NPA. And you know, if the project can be resolved, then they can always withdraw, because there is a withdrawal clause now in the IBC system. But projects should come fast, should come earlier. And even in the resolution process, what we see is there are all kinds of issues that are raised during the resolution process. Issues relating to claims, issues relating to diversions, issues relating to frauds, and so on and so forth. Now, resolving these issues is a time-consuming work. Now, you can't expect issues involving crores to be resolved in days. It's very difficult. So we have to think whether we can separate these issues with the resolution process. Let us resolve the project. Let us hand it over to the new person. Let him, with less loss of value, let him start running the company so that it can be sold as a going concern, and let us settle these issues separately. The money that comes from the resolution process can be deposited in the NCLT court, or a fund could be created, and it can then be distributed as and when a decision is made. That way, we will be able to preserve the project. I mean, that I believe is of prime essence, that whatever we do it within the time. Because if the whole pie becomes less, the distribution pie becomes less, then you know, all this fighting about claims and frauds and things, it, I think, becomes meaningless. So this is one point that I think should be researched, and I have seen that there are some papers which talk about this, but this is one issue I feel which needs consideration in the Indian context. The second point that Director Saab said about resolution versus liquidation. I mean, I can see that it is a very important topic, and you know, large number of our projects are going into liquidation. Large number of our projects, and but why are they going into liquidation? They are going into liquidation because, again, projects come here very late. So when projects come into the IBC process, that project is already, I mean, that factory or whatever is already closed for 2-3 years. And then the committee of creditors finds it very difficult to revive it. So naturally, it goes into, or liquidation is preferred. Our regulations also are tilted towards liquidation, and we will examine it. We are, I mean, in a month or two, we will examine it as to how to encourage resolution more than liquidation. Because the basic sense of IBC is to resolve a project as a going concern. That is the basic essence of IBC, and liquidation should really come as a last resort. Another issue on which there are 2-3 papers is interim finance. Now, if you want to preserve a company as a going concern, interim finance is a must. But when you talk to bankers, they say, we have already wasted so much money, should we give interim finance for a project which eventually it will go into liquidation? So this is again an issue which needs to be examined as to how to deal with things such as interim finance. The last point that I want to make about IBC is, IBC has done more outside IBC than inside IBC. I remember several years back, I used to be with Mr. Mehta ji on his board, Punjab National Bank board. And he I think in the first or second meeting, he told me an instance where someone's account had gone NPA. So that person came to him and said, my account has become NPA, so now it is your problem. It is no longer my problem because it's become NPA, now you run after me, I don't run after you. So, this is something that the IBC has changed. IBC has changed the relationship between the creditor and the debtor. This is what it has changed. And let me tell you, IBC may have given 2.5 lakh crores through resolutions, but more money has come outside resolutions. And it is the correct thing to do. I'm not saying it should not come. More money should come outside resolutions, outside the process. And we should encourage that money should come outside resolutions. Cases should be admitted, and then it is then that the debtor will enter into a serious negotiation with the creditor. And if he is able to give his dues to the satisfaction of the creditors, we should encourage withdrawal of cases. Another thing that we need to encourage here is mediation. I had called on the president NCLT, and he showed me a case where there was 95 IAs filed. Now, how can any judge take a decision on 95 IAs and then come to resolution within the fixed time? Now, we have to find a way of dealing with these IAs. And large number of people, large number of interested people, large number of stakeholders have a habit of filing IAs. And filing IAs in this case, I think you have to file a fees of just 250 rupees or 1,000 rupees, I think. So filing IAs is the easiest thing to do in IBC. So we have to find ways, we have to jointly find ways sitting with NCLT as to how to deal with these IAs. If in India, if we do not find a way of dealing with these IAs, we will never be able to make IBC a success. So something has to be done about these IAs. Something, I don't know as of now what can be done, but something has to be done as to how to deal with these IAs. Similarly, lot of time is taken in settlement of claims. Something needs to be done in settlement of claims. Now, under IBC, an information utility was created, and I think it was thought of that if all the information would be available with the information utility, and the claims should get out from should come out from the information utility, but people don't go to the information utility. People submit claims at all times before NCLT. Resolution plan has been submitted, now they file 5 claims. Now what do you expect the judge to do? He has to look at natural justice. Now someone is saying, this is my claim. Now he is faced with a problem. And we have to find solutions to these problems if we want to take IBC forward. So I think I've spoken enough, and I again welcome you all to this conference. I also thank the researchers who have written the papers. I promise them that in IBBI we will go through each paper and look at the recommendations. We will get back to you on several of your papers if we need more information, or if we as to how to implement them. I would again like to thank IIM Ahmedabad for helping us in organizing this conference. Thank you very much.
Thank you, sir, for your insightful thoughts. As you rightly said, the research papers are highlighting key issues, and the suggestions will certainly help us in policy making. Ladies and gentlemen, it is with immense pleasure that now I introduce our esteemed guest of honor, Shiri M Rajeshwar Rao. Mr. Rao is currently serving as Deputy Governor of Reserve Bank of India, having a rich experience in regulation, risk monitoring, enforcement, and legal affairs. Sir has spent almost 4 decades at the Reserve Bank of India. Sir, may I please request you to deliver the keynote address?
Thank you. Good morning, everybody. Honorable Minister of State for Corporate Affairs, Shri Rao Inderjit Singh, Shri Rajesh Verma, Secretary, Ministry of Corporate Affairs, Shri Ravi Mittal, Chairman, IBBI, Professor Errol D'Souza, distinguished guests, panelists, researchers, ladies and gentlemen. At the outset, let me express my gratitude to IBBI for inviting me to deliver this address at this conference. This conference quite appropriately focuses on one of the most important facets of a robust financial system, that is resolution of stressed assets. It would not be an understatement if I were to say that India has been witnessing a paradigm shift in the regulatory architecture concerning the resolution of stressed assets over the past few years. The Insolvency and Bankruptcy Code has had a profound impact on the creditor-debtor relationship in India. It's been a bit more than 5 years since the provisions relating to the corporate insolvency resolution process under the code were notified and implemented. And quite appropriately, it provides a window at this point for a stocktake of the progress achieved so far and the expectations about the future. For any lender, the credit risk, that is the possibility of not receiving timely payment of the contracted amount or of the counterparty not honoring its obligation in respect of a credit contract, constitutes a significant risk which needs to be covered by maintaining adequate capital and risk provisions. In principle, a borrower defaults when he is either unable to pay his creditors because of inadequate cash flows from his business, or the market value of his assets falls below the value of his liabilities, which hinders his capability to liquidate his assets and pay off his creditors to ensure that no default takes place. In such a situation, the borrower is said to have become insolvent. Unfortunately, in real-world situations, it's not easy to ascertain whether a borrower has become insolvent till the time the default occurs. Mostly by then, the marketable value of the assets of the borrower would have already fallen below its liabilities. As the liabilities of the borrower are assets of the lender, the inability of the borrower to pay its liabilities would reduce the value of assets of the lender, thereby impacting in turn their ability to repay their creditors, which primarily includes depositors in the case of banks. This is the main reason why the Reserve Bank is interested in timely resolution of stressed assets by the regulated entities. Even where the lender is not a bank, the interconnectedness of the financial system would lead to second-order effects that would adversely impact the financial system. Once a borrower becomes insolvent, the natural instinct of the creditors is to cut their losses by rushing for the biggest possible piece of the remaining pie of marketable assets of the concerned borrower. However, we also need to bear in mind the fact that a state of insolvency does not mean that the future prospects of the borrower are non-existent. In many cases, a judicious rebalancing of debt would suffice to bring it back on track, unless the financial stress is extremely acute. Almost always, a going concern should be more valuable to a creditor than a liquidated company. It is in this context that a comprehensive insolvency resolution legislation assumes importance. An efficient insolvency legislation would be premised normally on 5 pillars. 1, it should prioritize going concern status over liquidation. 2, it should force the creditors to come together and work out a resolution plan that tries to preserve the value by looking at options to keep the company as a going concern. 3, it should ensure a time-bound resolution so that the value deterioration for the creditors of an insolvent exposure is arrested. 4th, it must provide clawback of questionable transactions that may have contributed to the financial stress of the borrower, defaulting borrower. Finally, an effective resolution regime should protect the majority from the minority by forcing a cram-down if the majority decision covers a predefined threshold of approval. In addition to these principles, the resolution framework should also distinguish between the various classes of financial creditors based on the quality of security available to them, since the initial pricing of the credit instrument may have factored in the availability of security, and the lender stands to lose if such security is not reckoned while assessing his share of the resolution value. In the absence of such an accommodation, creditors are likely to demand higher compensation for credit risks that they are taking, thereby increasing the overall credit costs to the economy. While any resolution framework should prioritize preserving the value of the firm at the same time, going concern over liquidation cannot be an absolute preference. In the absence of ease of exit, overall production capacity in an economy will be held hostage to inefficient business ventures and prevent the economy from reaching to its potential if that were so. Thus, an effective insolvency legislation should not shy away from liquidating ventures when they are perceived to be costlier to the society, and that it would be more beneficial to unlock the value for redeployment. Prior to the enactment of the IBC in 2016, India had a plethora of legislations, each having part jurisdiction over the insolvency resolution of a borrower. You had the Sikh Industries Companies Act, you had the debt resolution tribunals, you had the SARFAISI, just to cite a few. While these laws had a positive impact on the resolution of stressed assets in the initial period after the enactment, the improvements tapered off over time. Moreover, the focus of the pre-IBC resolution efforts was more towards preservation of companies and employment, sometimes even at the expense of credit discipline and production efficiency of the economy. As mentioned earlier, timely resolution of stressed assets, especially by deposit-taking institutions, is of key interest to the Reserve Bank. In the absence of a comprehensive insolvency law in place, Reserve Bank had to put in place a series of schemes that emulated desirable features of an insolvency legislation. Thus, the earlier regulations mandated formation of a joint lenders forum which had a similar role to play as the current committee of creditors under the IBC. The asset classification standstill was comparable to the moratorium pronounced under the IBC. The requirement of majority decision being binding on the dissenting creditors was the regulatory equivalent of a statutory cram-down under the IBC. However, the statutory powers available to the Reserve Bank for resolution of stressed assets in the financial system is limited to entities regulated by the Reserve Bank, whereas unraveling of the complex web of financial contracts and rewriting them in consonance with the income-generating capability of the insolvent borrower debtor requires a comprehensive statutory framework with sweeping powers over the various types of creditors. Though well-intentioned, the schemes designed by RBI sometimes became a channel for the lenders to delay recognition of financial stress in the borrowers by postponing the actual asset classification. This paradigm has shifted under the IBC. The enactment of IBC in 2016 resulted in a paradigm shift in the efforts towards resolution of stressed assets in the financial system. The code marked a radical departure from the prevalent approaches that embraced the creditor in control model as against the debtor in possession model that had failed to produce any tangible improvements in the credit discipline in the country. Thus, the code fundamentally resets the power balance between the debtors and creditors in face of a default by the debtor. This approach is economically sound since creditors only have the contractually agreed share of the economic surplus created by a borrower, with the rest of the surplus going to the equity holders without any limits till a default occurs. At that point, the equity holders are protected by limited liability while the creditors stand to lose up to the entirety of their exposure to the insolvent debtor. In a single stroke, the code removed the divine right of the promoters to continue in the saddle, as has been observed by the Honorable Supreme Court, restoring the interests of other stakeholders, especially the creditors. The insertion of Section 29A provided further fillip to the notion that an insolvent debtor has to be protected from its own management, if required for the maximization of value from the debtor to the society as a whole. Thus, for the first time, the promoters faced with the possibility of losing control of their respective companies if financial stress is not addressed in a timely and in a comprehensive manner. The code also establishes the Committee of Creditors as a public institution with the paramount responsibility of ensuring maximization of value for stakeholders during the resolution of the corporate debtor. That the Committee of Creditors, which consists only of financial creditors, has to treat the individual interests as subservient to the larger public interest is a unique feature of the code as compared to similar legislations elsewhere. The code also enhanced the negotiating power of the operational creditors by allowing them to make applications for initiating the CIRP in respect of operational debtors who are in default. Of the total CIRP cases as of December 31st, 2021, more than 51% of the cases have been filed by the operational creditors. Such cases had a higher proportion of withdrawals as well, at over 50%, constituting 71% of the total withdrawal cases, indicating that filing the insolvency proceedings as a negotiating tactic appears to be working for the operational creditors. There have been some concerns about the high levels of haircuts that the creditors have had to take in the resolutions that happened under IBC. In these discussions, we missed the fact that a public auction-based resolution model, the extent of haircut represents the discount the market demands in continuing to invest in an insolvent borrower. Since significant value deterioration may have happened to the assets of the insolvent borrower, comparison with the outstanding amount may not be a reasonable indicator to evaluate the effectiveness of the resolution. Rather, the resolution values must be compared with the next best alternative for the creditors, which in this case is liquidation. Of the CIRP cases that have yielded resolution, financial creditors have been able to realize 166% in comparison to the liquidation value of debtors, indicating that creditors have been better off than the next logical outcome. Another often ignored aspect relating to the impact of the code is the credible threat of insolvency. A key metric for assessing CIRP applications that are withdrawn before admission. Till December 21, 19,800 applications for initiation of CIRP have had a total underlying default of about Rs 6.1 lakh crores were resolved before admission. In the absence of the code, it's most likely that these defaults would have lingered on for much longer, resulting in value destruction. Coming to the role of RBI vis-a-vis the IBC, what I would like to say is that even though RBI does not have a direct role to play in the CIRP process under the code, the RBI regulated entities are an important stakeholder for an effective bankruptcy law. With the increased levels of credit disintermediation, IBC becomes the most preferred tool available for a comprehensive resolution of debtors. The fact that the code can be leveraged to give an impetus to resolution of long-standing stress was recognized almost immediately after the notification of the provisions relating to CIRP under the code. This culminated in the Banking Regulation Amendment Act 2017, which vested powers on the Reserve Bank to issue directions to banks for referring specific default cases for resolution under IBC. Under these powers, as it's now widely known, RBI issued directions in June 2017 to the banks to initiate insolvency proceedings under the IBC in respect of the 12 largest debtors in the financial system, which were classified as NPA. These were followed by another set of directions in August 2017, where the banks were directed to implement time-bound resolution plans in respect of another 29 corporate borrowers in default, failing which insolvency proceedings had to be initiated against them. The enactment of IBC and the default event being the trigger for initiating insolvency proceedings under the statute forced a rethink of the regulatory trigger for mandatory resolution as well. We replaced all the prevailing schemes for restructuring with a simple and harmonized prudential framework for resolution of stressed assets in June 2019, which enshrined the following fundamental principles. 1. Early recognition and reporting of default in respect of large borrowers by banks, FIs and NBFCs. Complete discretion to lenders with regard to design and implementation of a resolution plan, subject to specified timelines and independent credit evaluation. A system of disincentives in the form of additional provisioning for delay in implementation of resolution plan or initiation of insolvency proceedings. Withdrawal of asset classification dispensation on restructuring. Future upgrades to be contingent on a meaningful demonstration of satisfactory performance for a reasonable period. Then, for the purpose of restructuring, the definition of financial difficulty was aligned with the guidelines issued by the Basel Committee on Banking Supervision. Signing of intercreditor agreements by all lenders was made mandatory, which will provide for majority decision making in the process. The approach of the Reserve Bank towards resolution of stressed assets outside IBC has been to incentivize timely initiation of resolution efforts, proper recognition of increased credit risk to lenders on account of concessions granted to them in the form of debt recast, and the borrowers are required to demonstrate that concessions have improved their viability by performing satisfactorily on their debt obligations during a reasonable period subsequent to the debt recast. A modern insolvency law such as the IBC deserves support and patience from all stakeholders, and attitude towards the new piece of law should not be influenced merely by losses materialized in respect of resolution of assets that have been stressed for a long period of time. At the same time, it is necessary to continue improving the regulatory regime for out-of-court resolutions through suitable harmonization of the regimes across the various categories of regulated entities, as well as periodic review of the framework to keep pace with the changes in the economy and the financial system. In order to strengthen the code further, we need to work on the following 4 dimensions. 1. IBC should not be the first resort for resorting to litigation. A comprehensive law like IBC is often viewed as a last resort by lenders, should be viewed as a last resort, an avenue that needs to be explored after exhausting all alternatives. However, this view stems from a lack of comprehensive vision for the future of a beleaguered borrower. Various classes of lenders are governed by a disjoint set of out-of-court resolution frameworks that apply separately to each class of lenders. Without participation of all lenders, any effort towards resolution is likely to be incomplete and would be mere postponement of an inevitable reckoning. The time lost in pursuit of such incomplete resolutions is likely to compound the eventual losses to the creditors and increase the cost to the financial system. Perhaps this is an issue which the researchers could ponder on. What is the average time taken between default by a borrower and the eventual filing of application for the insolvency resolution by creditors? It should also be interesting to see the relationship between such filing delays and the value deterioration that the creditors are required to recognize subsequently. Another disconcerting aspect is the time taken between filing of an insolvency application and the eventual admission of the application. The code prescribes a period of 14 days. However, in reality, the admissions take much longer time than that. A consultation paper released by IBBI in April 22 notes that the average time taken for admission of an insolvency application has increased from 468 days in 2021 to 650 days in 21-22. This is much longer than the stipulated deadlines for completion of a CIRP under the code. Such delays are likely to reduce the efficiency of the IBC as a comprehensive bankruptcy law and may weaken the creditor rights and ease of exit for bankrupt borrowers. there should be an increase in the coverage of pre-pack resolutions. Like any piece of legislation, IBC also needs to evolve with the changing economic fundamentals. The present review architecture in the form of a standing committee on insolvency law has been doing an exemplary job of ensuring the same, guided by the regulatory capabilities of the IBBI. The new dimensions being introduced to the IBC, such as the new module of the pre-packed insolvency resolution process, the PPIRP, or the pre-packs, which combines the best of out-of-court resolution and the judicial finality of a resolution plan approved by an adjudicating authority, are welcome. Even though the pre-packs have been presently allowed only for the borrowers that are classified as micro, small, and medium enterprises, we could envision the pre-packs as a natural complement to the prudential framework of the RBI. It would be worthwhile to consider extending the pre-packs to all borrowers. Finally, another dimension which needs attention is group resolution, one in which the resolution of borrowers belonging to the same corporate group is undertaken together. We saw an example of this during the resolution of the Videocon group. However, the same was put in place through discretionary powers available to the adjudicating authority rather than through a feature of the code. Such a process is especially vital in an economy like India, where traditionally credit contracts have been embedded with cross obligations and credit mitigating covers provided by parent and group companies of a borrower. In such a system, the default by a borrower is likely to spur cross defaults by group companies, thereby increasing the overall credit risk to the financial system. Deepening the credit risk markets in India is a necessary condition to take the financial system to the next level of sophistication. Reserve Bank has been taking many steps towards this in the recent times. The guidelines covering transfer of loan exposures have been reviewed and harmonized across all lending institutions. The secondary market for stressed loans has been thrown open to transferees who are not regulated by the Reserve Bank. The recommendations on the Committee on Development of Housing Finance Securitization Market and the Task Force on Development of Secondary Market for Corporate Loans are being implemented in phases. One of the major recommendations of the latter, the Self-Regulatory Organization for Secondary Market for Corporate Loans, has been implemented with the setting up of the Secondary Loan Market Association. RBI is also exploring further avenues to deepen the credit risk markets by exploring the feasibility of allowing additional type of securitizations. At the same time, we would expect the lenders do not wait for a default by the borrower to initiate resolution processes. The lender should combine prudent risk pricing of their exposure with ongoing monitoring of the exposure and maintenance of adequate capital and risk provisions. Additionally, since the point at which a counterparty has become insolvent cannot be pinpointed accurately, the risk management practices of the lenders have to be sophisticated enough to capture the changes in risk factors that may affect the safety of the said credit exposure. Lenders should also perform periodic stress tests to estimate possible trajectories that the credit exposure is likely to take and calibrate their responses accordingly. Ultimately, they are responsible for safeguarding their own interests and the interests of their stakeholders. To sum up, we have come a long way in improving the credit discipline in the country. However, as with any public policy, it's always a work in progress with scope for improvement at any point in time. RBI will continue to engage with the stakeholders to improve the resolution frameworks and adopt more sophisticated and updated risk management practices to take care of systemic concerns that arise from the activities of the various credit intermediaries. With this perspective in mind, I wish that this conference generates very insightful debates on the various issues which have been highlighted and will guide us in the times to come. Thank you.
Thank you, sir, for your insightful views highlighting the interplay of regulatory provisions by RBI and IBBI in resolving the financial stress. Ladies and gentlemen, may I now introduce our guest of honor, Shiri Rajeshwar Rao, Secretary, Ministry of Corporate Affairs. Shri Verma has held several key positions in his illustrious career as a civil servant. He is a 1987 batch Indian Administrative Service officer. At the Secretary of Ministry of Corporate Affairs, he is leading the policy discourse for the effective and efficient implementation of the Insolvency and Bankruptcy Code. He has steered major amendments in the law to address various challenges arising during the implementation of the code. We extend a warm welcome to you, sir, and we request you to kindly address the audience.
Honorable Minister of State for Corporate Affairs, Shri Rao Inderjeet Singh Ji, Shri Rajeshwar Rao, Deputy Governor RBI, Shri Ravi Mittal, Chairperson of IBBI, Professor Errol D'Souza, Director IIM, Ahmedabad, members of the Governing Board of IBBI, members of NCLT, researchers, professionals, officials of IBBI and Ministry of Corporate Affairs, faculty of IIM, Ahmedabad, ladies and gentlemen. It gives me immense pleasure to be addressing this research conference on a very topical subject of insolvency and bankruptcy. An economy prospers when its limited resources are optimally utilized. This happens when businesses have maximum possible freedom to reshuffle resources among alternative uses continuously and seamlessly. Freedom unleashes and aids in realization of the full potential of every business and every resource in the economy. With this understanding, among the primary duties of the state, therefore, is to provide right institutional milieu that promotes and protects economic freedom and regulates such freedom only to address market failures. According to Nobel laureate Professor Joseph Stiglitz, anybody who knows about capitalism knows that bankruptcy is an essential part of capitalism. Hence, one of the important economic freedoms that is required for businesses to flourish and vacate the space when they are not doing well for reasons beyond their control is the freedom to exit businesses in a dignified manner. The journey of reforming the existing institutional structure to address this issue of providing freedom of exit to the firms started with the enactment of the Insolvency and Bankruptcy Code in 2016. Government has been proactively responding to further strengthen the insolvency framework and make the processes under the code more efficient and effective by resolving issues encountered during its implementation. As the former President of India, Dr. APJ Abdul Kalam put it, excellence is a continuous process and not an accident. The code has been amended 6 times till now. Major amendments included preventing undesirable persons from taking over the corporate debtor, Section 29A, which was alluded to. Recognizing home buyers as financial creditors, requiring completion of corporate insolvency process in a time-bound manner, which is a very important key feature of this whole law, ensuring going concern status of the corporate debtors by providing that the licenses and permits shall continue during the insolvency process, granting immunity to successful resolution applicants from previous misdeeds, Section 32A, and most recently, providing a simplified prepackaged insolvency resolution framework for the MSMEs. Now, of course, the demand is to extend it to other corporate debtors. The code is hailed as one of the most important economic reforms of recent times, which has been guided by government's vision of making doing business easy in the country. I am sure this august audience is well aware about the outcomes of the code. However, at the risk of sounding repetitive, I would still like to draw your attention to certain key takeaways from the implementation of this code. As a progressive economic legislation, the code has shifted the balance of power from the debtor to the creditors. It has inculcated a sense of financial discipline and brought about greater certainty of outcomes of the process of insolvency resolution. The law, being preventive in nature, is bringing about a cultural shift in the dynamics between lenders and borrowers, and promoters and creditors. the first signs of distress are now perceived as an early warning for management to take corrective action to avoid defaults. The code is emerging as a behavioral law, drawing various stakeholders of the entity in distress to work together in a non-adversarial manner towards the laid down objectives of the law. This is also proven by the fact, also mentioned by Mr. Rajeshwar Rao, that more than 20,000 applications for initiation of the CIRP under the code involving an amount of more than rupees 6 lakh crore have been withdrawn before admission. By providing a clean and dignified exit, the code is aiming to inculcate an entrepreneurial culture which recognizes failures rather than condemning it. Till March 22, 1,219 corporate debtors have opted to exit their business efforts voluntarily. So, code provides for voluntary liquidation. 317 of them have successfully exited, and till March 22, 5,253 applications which were admitted for CIRP, 731 applications were closed either on review or settlement, 586 applications were withdrawn under section 12A. One of the speakers was mentioning about that. 480 corporate debtors are on their way of revival with the approved resolution plans, while liquidation has been ordered for 1,608 entities after due process. Many of these cases, in fact the liquidation cases, were long pending in the erstwhile BIFR process or were defunct, so that the economic value had already immensely deteriorated before they came for the under the fold of IBC. The 480 CDs, corporate debtors which have revived, they owed about 7.5 lakh crore to the creditors. The assets of these debtors were valued at only 1.3 lakh crore when they came into the IBC. The realizable value for creditors through the resolution clause was 2.33 lakh crore. So, the liquidation value was 1.3 lakh crore, the realizable value was 2.3 lakh crore. So, it is almost 178% of the liquidation value. Though of the admitted claims, the realizable amount was 31% only. The creditors made a considered choice of reviving these companies, keeping in mind the long-term benefits in rescuing them rather than short-term recovery of the loans. With these numbers and quantitative outcomes at the back of our mind, I wish to dwell upon the course that the law can take in future, guided by research and analysis by the scholars and experts such as all of you present here. However, before I do that, let me recognize that research efforts that have been undertaken are ongoing in the area of insolvency law in India. Several initiatives have been taken by government and the IBBI for promoting research in the area of insolvency law, and these are leading to the policy discourse. The Ministry of Corporate Affairs has been releasing discussion papers proposing reforms in the insolvency law from time to time. We seek to steer the policy discourse in the area of insolvency and crowdsource ideas to make the reform inclusive, dynamic, and grounded. Most recently, the discussion papers on certain amendments to the code and introducing provisions relating to cross-border insolvency resolution were floated, eliciting comments from the general public. Since data is one of the essential ingredients to any research, IBBI has been collating a dynamic data set relating to processes and outcomes under the IBC to encourage evidence-based research in the insolvency space. It has also been promoting research and publication through insolvency professional agencies and academics. The IBBI has also been encouraging the submission of research papers and working papers on various issues and processes through its various research initiatives, such as the IBBI Research Initiative and Working Paper Series. The envisaged IBC 21 electronic platform would improve data management and data dissemination on insolvency. It would essentially support easier access and use of data that facilitates meaningful policy-oriented research. legal research on the emerging jurisprudence from code is being undertaken by the stakeholders. There is now a growing body of literature that aims to address the gaps between theoretical aspects of insolvency law and its practice and impact on the ground. Evidence from the qualitative and quantitative research can be used by the experts for designing, improving, and testing government policy. Empirical research will aid policymakers in applying theory to practice and achieving real world outcomes. Let me now turn to what I think should be the direction of research and analysis in the area of insolvency law in India. The government and the regulator IBBI have been constantly course correcting and responding to any areas of gap in the code and associated rules and regulations to ensure that it works towards meeting the objectives enshrined in the preamble itself. While we are working with agility as regards implementation of the provisions of the code based on the stakeholder consultation with the subject experts, going forward, it is important that we have a rigorous and evidence-based research to public policy. Policies that are not backed by appropriate evidence, research analysis may not yield the desired outcomes. The IBC is one such economic legislation whose origins lay in the sound research and evidence as put together by the Bankruptcy Law Reforms Committee in its report. The IBC has since then evolved through various amendments that responded to the evidence from the ground. As I had mentioned earlier, Ministry of Corporate Affairs comes out with the discussion papers before taking a policy decision. Our experience shows that we get inputs mostly from law experts and practitioners in this area. We would like to encourage researchers, academicians, and economic experts to provide inputs for further policy directions to the code to make it more vibrant and inclusive. The first area which I feel requires in-depth research is to document and peer review the journey of IBC till now in terms of where we are as compared to where other jurisdictions were at this relatively early stage of the enactment of a modern insolvency law in their respective jurisdictions. It was not that in the early days the countries did not face difficulties and challenges and had not course corrected. Policy observers often end up comparing our 5-year-old regime with the regimes of mature economies where the modern insolvency laws have been in place for a very long time. Some critics have observed that the IBC has led to more liquidations than resolutions, and large haircuts are being taken by the creditors in a resolution process. It would be instructive to examine outcomes of Indian law with those of other jurisdictions at the early stages of implementation of reforms in those countries. There is presently no standard framework to track outcomes of insolvency and bankruptcy regimes in various jurisdictions other than the World Bank doing business report indicators, which too has been also discontinued recently. One of the IBBI working groups has dwelt precisely on this issue and is providing a starting point of a framework to evaluate the outcomes of IBC. I would encourage researchers to take this forward and publish work on the salient features and results of IBC so that the Indian regime becomes a model for other countries to learn from. Topics of relevance in this regard may be how the admission and disposal processes are handled by the courts, how are avoidance transactions dealt with in a time-bound manner, what should be the monitoring framework for insolvency and bankruptcy professionals assisting in the insolvency resolution and bankruptcy framework, how the whole process monitored, what kind of granular data is available to measure the outcomes of the processes. The list can be practically endless, as we can have learnings from each and every aspect of the process from other countries. It is crucial to continue to study the impact of insolvency framework created by the IBC and conduct a SWOT analysis, investigate its strengths, weaknesses, opportunities, and threats on a regular basis. Research can provide pointers on how the legislative framework may need to adapt to meet future goals and challenges. COVID-19 pandemic led countries around the globe to tweak their insolvency laws to save businesses from closing down due to fallout of the unprecedented crisis. Government of India too amended the code, by suspending the initiation of the corporate insolvency resolution process for a period of 1 year to prevent viable companies from being pushed into insolvency proceeding for their failure to service debt obligations on account of pandemic-induced stress. The threshold of default for initiation of CIRP was also revised from rupees 1 lakh to 1 crore. A number of other measures were taken as a part of Atmanirbhar Bharat package to help businesses and individuals in distress due to a once-in-a-lifetime event of global pandemic. Preparing the ground now for the post-pandemic world requires focus on saving businesses which provide bread and butter to survive. This is also essential for long-term economic resilience and growth. How should the insolvency law respond to the new realities emerging in the post-COVID-19 economic environment? How can the law be further streamlined to ensure efficient and effective resolution of financial stress of the corporates? What more can be done for the MSMEs are some of the questions that research can help answer and provide policy guidance. Let me conclude by suggesting that there is a need to develop a research culture within the regulators such as IBBI with a critical mass of in-house research strengthened by establishing links with academic and research bodies such as IIMA Ahmedabad. I am pleased to see these links here today at this conference and hope to see many more such collaborations. I am confident that this research conference spread over 2 days and with presentation of about 40 multidisciplinary research papers will ask the right questions and present answers, backed by evidence that will enhance our understanding of the IBC, its impact on the economy and society, and most importantly, the way forward for this law. I note that the papers being presented at this conference are on varied topics around the insolvency and bankruptcy framework in the country, such as the behavioral aspects of the law, application of mediation in corporate insolvency situations, cross-border insolvency law for the country, predicting bankruptcy for MSMEs, interim finance ecosystem of the country. These are all topics of interest and will help mold the future of the modern insolvency law. I wish the conference the very best. Thank you.
Thank you, sir, for your insightful views on the journey of the code, emerging jurisprudence, and the outcomes of the code, and also for highlighting the role that research plays in policymaking. Ladies and gentlemen, it is indeed my privilege to introduce our esteemed chief guest for the occasion, Shiri Rao Inderjit Singh. Shiri Singh is a Minister of State with independent charge of the Ministry of Statistics and Program Implementation, Minister of State independent charge of the Ministry of Planning, and Minister of State in the Ministry of Corporate Affairs. Shiri Singh is a Member of Parliament in the 17th Lok Sabha and has been active in public service for over 4 decades. Shiri Singh is the descendant of Shri Raja Rao Tularam, a freedom fighter of India's first war of independence in 1857. He is an international shooter and won various medals for our nation. He also holds national record twice at the National Shooting Championship. Sir, we are delighted to have you here and we request you to kindly address the audience.
Shri Rajesh Verma, Secretary, Corporate Affairs. Shri Ravi Mittal, Chairperson, IBBI. Professor Errol D'Souza, Director, IIM Ahmedabad. Mr. Rajeshwar Rao, Deputy Governor, RBI. Mr. Sudhakar Shukla, full-time member. Other members of the governing board of the IBBI, stakeholders who have joined online, ladies and gentlemen, please bear with me. I'm not as hands-on as some of the speakers before me, so I too would like to read out my speech. I shall attempt to be brief. To begin with, I would like to thank both IBBI and IIM Ahmedabad for having me here, and it is a great honor to be part of this prestigious conference. I am certain that this conference will bring new perspectives to the ever-evolving law of insolvency and bankruptcy and highlight the unparalleled progress that has been made so far. The Code has seen many challenges and has adapted to the realities of the Indian economy. Supporting the growing Indian economy in the early 2000s, the credit market also expanded at that time. An unintended consequence of credit expansion is the possibility of default. Against the backdrop of looming NPA crisis and the twin balance sheet problem of in 2016, the government enacted the Insolvency and Bankruptcy Code. The journey of this landmark legislation has been marked by important policy and institutional developments, including 6 amendments to the code, validation and learnings, achieving institutional milestones, awareness building, and capacity building for all stakeholders. The code has established well-functioning institutions and regulations. Through efficient insolvency resolution procedures, the code has enabled banks to resolve their NPAs after having peaked at around 11.6% in March 2018. Due to the increased pace at which NPAs were recognized, the gross non-performing asset ratio across all scheduled commercial banks has come down to 6.9% in September 2021. As reported by the RBI, the IBC has continued to be one of the major modes of resolution of NPAs by banks since its enactment, vis-à-vis scrutinization and reconstruction of financial assets and enforcement of securities interest, debt recovery tribunals, lok adalats, etc. One of the most remarkable achievements of the code has been the significant behavioral change that has come about amongst the debtors and creditors alike. It has also been conducive to the budding entrepreneurs, stirring animal spirits, and opening up credit channels for investment. The startup ecosystem got a major boost from the IBC as the code has improved the business climate in the country by making it easier for enterprises to exit in case of difficulties. The IBC has provided the required market price discovery process, which gives greater confidence to the lenders. The code also assumed greater significance post-COVID-19 pandemic. Adapting to the new normal, swift actions by the government in response to the pandemic prevented many viable firms from being prematurely pushed into insolvency. This saved both lives and livelihoods. The IBC has, till now, evolved and attuned to every emerging market requirement. With the enactment of the code, India has witnessed the birth of 2 professions, namely insolvency profession and valuation profession. The code has opened unlimited possibilities of resolution, including merger, amalgamation, and restructuring of any kind, which often requires professional help. This has expanded the market of services of advocates, accountants, and other professionals. While the code has had a remarkable journey so far going forward, evolving with changing scenarios will be crucial. Cross-border insolvency is the buzzword in the insolvency and bankruptcy sphere in India since the government released a draft chapter on cross-border insolvency. The proposed cross-border framework will govern all applications seeking recognition of foreign insolvency proceedings as well as applications from foreign jurisdictions seeking cooperation in Indian jurisdiction. This landmark step is expected to redefine India's relations with the rest of the world, furthering the use of the recently introduced pre-packaged insolvency resolution process for corporate MSMEs will allow us to analyze the process and address emerging challenges, if any, in this sphere, as India experiments with the first of its kind pre-pack framework that is unique and tailor-made as per the defining needs of our country. Like everything else, this reform too should keep evolving. This means only one thing, that is embracing the future, such as group enterprise, insolvency, individual insolvency, etc. Resolution of the financial service providers under the code is a welcome development for the IBC. It needs careful evaluation going forward, given the subsequent impact it will have on the entire ecosystem, touching the economic, social, as well as the legal fabric of the country and going beyond just a few specified stakeholders. Streamlining the CIRP and liquidation process will further remain a key priority going forward to consolidate the progress already made and secure future gains to the economy. To ensure timely admission and key responsibilities of the Committee of Creditors, it is an appropriate time to adopt a code of conduct for them to further strengthen the institution. As IBC evolves further, it could become the most potent instrument in driving good credit behavior and ethical business practices amongst borrowers and proactive, responsible behavior among lenders, proving to be a boon for the economy and to the nation. We must learn from the outcomes and strengthen the code so that the law is robust over time. With a view to charter a credible way forward with effective participation of academicians, policymakers, researchers, and other stakeholders alike, the government has been making concerted efforts to build discourse around critical aspects and best practices webbed around the insolvency space in the country. The IIM Ahmedabad is one of the most prestigious institutions of India, and rightly so. They and IBBI have joined hands to hold this research conference. I would like to congratulate all the participants for being selected to be a part of this prestigious conference. The knowledge shared over the next 2 days will go on to stir many minds that will be fundamental in shaping the future trajectory of the IBC. My good wishes to all you participants.
Thank you, sir, for providing insights on how the code is future ready and how the code has embraced the economic reality so far. Ladies and gentlemen, may I now request Professor Errol D'Souza, IIM Ahmedabad, to present a small memento as a token of our gratitude to our esteemed guest on the dais. May I request Shri Rao Inderjit Singh, Minister of State Corporate Affairs, to kindly accept the memento. May I request Shri Rajesh Verma to kindly accept the memento. May I request Shiri M Rajeshwar Rao, Deputy Governor, RBI, to kindly accept the memento. May I request Shri Ravi Mittal, Chairperson, IBBI, to kindly accept the memento. May I request Shri Sudhakar Shukla, WTM IBBI, to kindly accept the memento. May I now request Professor MP Ram Mohan, IIM Ahmedabad, to present the memento to Professor Errol D'Souza. Thank you, dear dignitaries. Ladies and gentlemen, may I now introduce the whole-time member IBBI, Shri Sudhakar Shukla. Mr. Shukla has been with the IBBI as a whole-time member for more than 2 years. Sir is an Indian Economic Service Officer, having an illustrious career in various ministries. Sir has contributed in core policy matters. Sir, may I please request you to deliver the vote of thanks.
Ladies and gentlemen, I rise to podium to express my deep sense of gratitude, not only to the dignitaries present on the dais, but all of you who have made the journey of IBC so credible. Not only people and researchers present here in this hall, we have 2 more halls adjoining where some of our colleagues are listening to this live podcast, basically. So thanks to them also for joining us. And online we have around 1,000 plus people who have joined this event live. So there is a louder message that IBC has arrived and it's maturing with time. On behalf of IIM, Ahmedabad and IBBI, and esteemed partners of Mishra Center of Financial Markets and Economy, IIM, NSE, SBI, BSE Investor Protection Fund, and NISM, it is my proud privilege to express my sense of gratitude to Honorable Minister, who has taken his busy schedule some time out of it and came here to bless the conference, and he gave his thought-provoking message. And his message was very clear that this fascinating journey has just begun, and there is no scope for stagnating at the peak. We may think peak has arrived, but we have to work overnight to see that our goals are redefined every day, every moment. So thank you, sir, for being with us and giving the keynote address. My thanks are also due to Secretary MCA, and as famous Daniel Moran says that you can have data without information, but you cannot have information without data. So he rightly stressed that we need to have some kind of format, because the goalpost has shifted from output to outcomes. So measuring outcomes is not an easy task. You have to have a path-breaking standards to achieve the kind of glory which is attached with the outcome assessment. So that is a clear message that we have to work a lot. World Bank has discontinued its ease of doing business index, but surely under your leadership we would be trying to have some kind of outcome indexing being done as part of IBBI, also in partnership with IIM. We are sure we will be able to do and have a kind of parameters involved which are much beyond what the scope of World Bank index was providing. So thank you, sir, for this message, and that is the work in progress. We have to do a lot on that part. I also thank Deputy Governor RBI for excellent exposure to what RBI and IBBI relationship is all about. We proudly remember the 12 big CDs, big industries which were basically transferred literally by RBI to be settled in under the IBC processes, and that kick-started the whole journey. Apart from that, Creditor Information Companies Act was basically amended to see that information utility gets all the information. And also our joint experimentation with FISP is showing some credible results on ground. So moving forward, we have noted your concerns and what we have to do in future, but in taking this partnership ahead, I thought we have to see that Sudarshan Sen Committee report on ARCs is out, and we are waiting the clearance from RBI on that. And also we are waiting to have some credible and intense partnership on code of conduct for the COC members. So we have evolved, but we will be looking forward for some hand-holding, some support in moving forward. So that is a wish list. We will be working together with RBI all the time. I'm also thanks Professor D'Souza. It was welcome speech, I thought. We have noted your concerns about shareholders' right, and sometimes we meet with SEBI also with similar kind of concerns that at least minority shareholders should be covered within the ambit of IBC so that they can get due reflection in the processes. So, but Section 53 and Section 29A are very clear what we intend to do, but definitely we can see that what kind of changes in times to come would be possible. We look forward, sir, for continued engagement as a knowledge partner. I am Ahmedabad being the knowledge partner with IBBI, sir. Chairperson IBBI was very candid in his assertion. I thought he is very clear that in what Edward Deming says, if you do not know the how to ask a right question, you will discover nothing. So at least when we come in the morning, some questions, right questions are ready to be deliberated whole day to see that how processes are to be reformed, because 5-6 years we were consolidating the reform processes, and now we are trying to see that these reform processes should be efficient in delivery. So this shift in paradigm we are witnessing right now under the new leadership. Thank you very much, sir, for your speech. And last, I just wanted to also thank my colleagues, researchers, basically, who have joined from 4 countries, sir. Basically, we have from UK and from US and Mauritius, Argentina. So 4 countries are represented here. We welcome them also because that it makes a truly a recognition that this is an international conference, and also the 40 researchers which are presenting. We are seeing 40 today, but when we started in December, we got around 65 papers, and there was a rigorous scrutiny and third-party evaluation whether these papers graduate or worth for this kind of workshop to be presented. So out of 65, 40 were selected, and they are here, and we will be looking forward for the key messages. So thank you very much. I thought thanks to press also for being extensively covering this event, and we hope tomorrow's newspaper we will also see some of the reflection what key messages have come out of this opening session. I also thank the team who worked very tirelessly. I think Professor Ram Mohanji and Ritesh from IBBI, ED. That team entirely actually was pulling off, and last 15 days I have seen that struggling, that who is arriving, who is not arriving, who is the substitute. So lot of effort has gone into to see that this show begins with a grand opening. Thank you all for being here. Thank you.
Thank you, sir, for your kind address. Ladies and gentlemen, may I now request all to kindly join us